Assalamualaikum everyone. We will continue our syllabus in Malaysian Industrial Relations with topic 5, Recognition of Trade Unions. This is our learning objective for this topic. You will be exposed with the definition of recognition, why it is important for the trade union to be recognized by the employer. You will also learn about the scope and types of recognition. What are the requirements for trade union in order to obtain the recognition? What procedures to follow? But at the same time, there will be some problems faced by the trade union to get the recognition. And last but not least, you will learn what is the effect of recognition. Introduction. One of the important reasons why employees form trade union or join trade union because they want to be recognized by the employer and by law. Because as we know, once the employees join trade union, they expect to be protected from any exploitation, manipulation by the employers. Through trade union, employees will have the opportunity to improve and obtain a better terms and conditions at workplace, which can be done through collective bargaining. However, before the employees or trade union members can enjoy this privilege, this right, their trade union must obtain the recognition first. It is considered as prerequisite for the trade union before they can act legitimately to do such activities. Meaning of recognition. This is the definition of recognition. According to Maimunah Aminuddin, recognition means an individual employer is willing to accept the union as the rightful representative of his workers. Representation is so important in the collective bargaining process and in the interest of harmonious industrial relations. Basically, why recognition is so important? This is because trade union cannot do the collective bargaining before they get the recognition. Okay, brief introduction on what collective bargaining is all about. Collective bargaining, according to Boone and Cross, is the process of negotiation between management and union representative, which is the trade union, for the purpose of arriving at mutually acceptable wages and working conditions for employees. And why collective bargaining is so important for trade union in industrial harmonious? Because it is the only legitimate platform for the trade union, which is representing the employees, to make a proposal and request for a better wage, raise of wages, as well as better working conditions. So, without obtaining the recognition, trade union cannot initiate collective bargaining. One thing we really need to understand is this process of getting the recognition is between the trade union and the employer. It means that the trade union needs to apply the recognition from the employer. Once the employer grants the recognition to the trade union, it is considered an official acknowledgement by the employer that trade union has the right to represent their members or employees, which is partly or the whole organizations accordingly. So why we need recognition? Because trade union needs to be recognized by the employer before collective bargaining can begin. Recognition to the trade union enables them to act as a representative to enhance stable and harmonious industrial relations between the employer and employee relationship. Without proper recognition, a trade union cannot commence contract negotiation, which is what we call the collective bargaining, with its employer. In summary, recognition is very essential for the trade union, and this symbolizes a harmonious relationship between both parties, employer and the trade union. This slide explains on the case regarding on the importance of recognition. However, it is important to note that the trade union can only be legal if the establishment and function as pre-registered according to the trade union as prescribed in the initial establishment and the trade union constitutions. In this case, it is clearly that the NUPW was initially established to represent their employees in newspaper publishing industry under the FPSB and STPD company. But once these companies discontinued and no longer serve the newspaper publishing industry, so the NUPW can no longer represent their employees and no more such things as recognition for this trade union. This is the statistics in Malaysia about claim for recognition. It means that these are the cases reported by the trade union on the prolonged case related to the trade union application to get recognition from the employer. Most cases are due to employers delaying, granting or awarding recognition to their trade union. As you can see from the slide, some cases reach to a settlement through voluntarily by the employer. Sometimes it recognition accorded by decision of the minister, which is the Minister of Human Resource, claim rejected by the employer and the DGTU, which is the Director General of Trade Union, due to several reasons such as withdrawn or union was found not eligible or not qualified or others. So why do you think employers tend to delay the recognition? Yes, it is because once the employer grant the recognition or accord the recognition, then the employer are bound to deal with the trade union on the collective bargaining. Why sometimes the employer a bit concerned if trade union start the collective bargaining? Because if the employer delay the process in collective bargaining or unable or fail intentionally or unintentionally to fulfill their promise in collective agreement, the employer will responsible. To a certain extent, this matter can lead to industrial dispute. If it getting worse and unresolved in harmonious way, this will bring to the industrial court. Scope of recognition. This slide explains about the blue-collar and white-collar employees union. White-collar workers typically perform professional, administrative or managerial tasks in office setting, while blue-collar workers typically engage in manual labor or skilled trades such as construction, manufacturing or maintenance. So, blue-collar cannot seek for recognition in respect of white-collar union and vice versa. Purpose of recognition. This slide is to emphasize why recognition is important. Basically, recognition is important for trade union to commence their collective bargaining. However, it depends on whether the trade union has the general recognition or limited recognition. What is general or limited recognition? Let's move to the next slide. Types of recognition. Basically, there are two types of recognition. The first one, limited recognition. It is when the union membership is a minority in the company, not more than half of the total employees being a member of the trade union. While the second one, general recognition. It is when the union membership is a majority in the company, which is more than half of the total employees in the company are being a member of the trade union. Okay, now let us begin with general recognition. It is given to the trade union where its members represent the majorities of workers at the workplace. So it's required must carry at least 50.1% of workers joining the trade union in the organization. So what is the implication if the trade union get the general recognition? Or you may call this as the advantages for the trade union who obtain general recognition. The first one, the union can commence collective bargaining, which I have mentioned before. Second one, the union can represent members of the trade union as well as the non-members of the trade union in the case of employees' right and welfare which may affect to industrial dispute. Thirdly, trade union has given the rights to claim, negotiate and discuss with the employer on general problems or issues related to working conditions, for example, like working hours. So, how about limited recognition? So, since the membership of the union is just a minority, remember, less than 50% are the union members, so it implies that the union is only entitled to make representations on individual grievances, such as unlawful dismissal, disciplinary action without following procedures, and etc., and to negotiate on behalf of its members of trade union. The trade union can only claim asked to represent his own members in cases related to grievances or personal satisfaction, but the union cannot initiate or do collective bargaining. So what is the implication of limited recognition? First, the union cannot commence collective bargaining because it is only for the individual grievances. Secondly, it can represent union members only, other employees who are not member of the union. If something happened, for example, like unfair treatment, or you feel your rights and welfare is violated by your employer, you have to fight your case by your own, by yourself. Okay, so you have to report to Human Resources or Department of Labor all by yourself without assistance from the union. So kind of disadvantage for you. Thirdly, since the membership of trade union is minority, indicates low and poor support from employees to join the trade union. So, trade union is prohibited to negotiate or to bargain in order to help members to solve problems on behalf of all workers at workplace. Well, nothing much about this slide. It's just to differentiate between general and limited recognition, as I have explained in the previous slides. Next, requirement of trade union. So, on what ground the trade union can apply for recognition? The trade union must fulfill these criteria before the trade union are qualified to apply for recognition from their employer. First, the union must be legally registered union. Trade union must be registered with the Department of Trade Union through legal and official channel and process. So for this one, please recall topic 2. Secondly, the union must make formal application or claim. Remember what I have told you before, to get the recognition, the trade union must make official application. To whom? To the employer, not to the Director General of Industrial Relations. So please take note on this. Thirdly, the union must be competent to represent the employees concerned. The officers of trade union must be well trained, knowledgeable and reliable to represent the employees in the organization, well versed in terms of unionism issues, right and welfare at work, and also legal literacy, and etc. Fourthly, the union must be appropriate union to represent the employees concerned. Perhaps there will be a multiple union in one organization, so it should be the appropriate and relevant union to represent the respective employees. Importance of recognition. First, both parties, which is the employer and employee, may commence collective bargaining. We will discuss further about it in the next topic. Secondly, trade union may set out the proposal for collective agreement based on collective bargaining on any matters such as right at work, welfare, wages, working conditions related to facilities, and etc., except on managerial capacity. Managerial capacity can be referred to managerial prerogative, which is something that belong to management and not negotiable, such as right to hire, terminate, transfer, promotion their employees, and etc. Thirdly, trade union has the power to force employer to listen to the union members' grievances, claims and suggestions via collective bargaining, negotiation, and etc. Fourthly, to represent workers in trade disputes. It reflects to disagreement between employer and union, unfair treatment, collective agreement, and etc. So these are the advantages of recognition to employees union. Firstly, it allows workers to invite employer for collective bargaining. Secondly, indicate that employers are ready to listen to workers' opinion, because once the employer granted the recognition, then the employer should work together with the union, involve union in certain decision-making levels, and etc. Thirdly, is a mechanism for discussion on many issues like mentioned before. Number 4, hinder or avoid arbitrary action which can jeopardize the employees. It is important for us to understand the process to apply or to claim for recognition. This diagram explains the step-by-step process for recognition application from the trade union to the employer. So, first and foremost, the trade union must write and fill up relevant form to claim or apply for recognition from the employer. So, in result, there will be 4 scenarios after the union submit the application. First, the employer must reply to the application made by the trade union, either to grant or to accord, and to give the recognition or not to accord the recognition to the trade union. If the employee agreed, then the process ends. As simple as that. And the union can enjoy the privileges of recognized trade union with possibilities to commence collective bargaining. Secondly, in some cases, the employer refused to accept, or simply put, the employer may not grant the recognition due to several reasons, such as if the employer found some discrepancies or irregularities of the trade union credibility and membership. If the employer refused to accord the recognition, the best way is the employer need to reply the application to the trade union in writing with justification. However, if the trade union dissatisfied with the justification, the trade union may report to Director General of Industrial Relations so that the DGIR will carry out investigation towards the employer. This will depend on situation and may go to upper levels such as DGIR and Minister. Third, in certain cases, upon receiving the application from the trade union, if the employer found some irregularities and the trade union, the employer may apply to the DGIR to check on the membership of the trade union. It is about the validity of the membership according to the trade, occupations and industry, blue or white collar, etc. So in this case, the trade union has to wait until DGIR deliberately provide the result. Fourth, if the employer ignores the claim or application either intentionally or carelessly, then the trade union may report to DGIR so that the DGIR may inquire the employer to respond the application accordingly. So this will explain the procedure with 6 steps to detail up my explanation on the previous slides. Step 1. The claim must be made in writing and in the prescribed form by the union. So which is what we call a claim for recognition form or Form A. So relationship between the union and employer. Step 2. The employer once received the claim or application must within 21 days must reply either to accord recognition or to refuse to accord the recognition to the trade union. If the employer does not accord, he is required to notify the union in writing of the grounds for not according recognition, employer to the union. Step 3. The employer may also, within 21 days upon receiving the application from the trade union, to apply to DGIR to ascertain whether or not the union fulfills the requirement for recognition, which I have explained in slide 17 just now. So it is between the employer and the DGIR. This is the example of the form that need to be filled up by claiming the recognition. As you can see, it is to be submitted to employer but need to CC, enclose and submit a copy to DGIR office. We'll continue. Step 4. The union may file a complaint in form of written report to DGIR if the employer either refuses to accord or fails to comply with the mentioned requirements. So it is between the union and DGIR. Step 5. DGIR, upon receiving either an application form from an employer or a complaint from union, so it is authorized to take any step to resolve the dispute, or it is also authorized to compel the employer or an employee to furnish information to resolve the disputes. So this is between the GIR and the employer. Step 5. If, despite his efforts, the dispute is not resolved, the DGIR is required to notify the Minister of Human Resource, and then Minister of Human Resource is required to resolve it. So it is between DGIR to Ministry of Human Resource, then from the Ministry of Human Resource to the employer. Step 6. If the Minister decides that recognition is to be accorded to the union involved, then the recognition shall seems to be accorded by the employer concerned as from such date as the Minister may specify. This is another law case regarding to this issue. Sun Seng Cement Products Sdn Bhd and another versus Non-Metallic Mineral Product Manufacturing Employees Union and others. So this case explains about the union submit a claim for recognition to the company, which is to the employer. Obviously, the union has majority members in the company, which is more than 50% of the employees became a member of the union. However, the company refused to accord recognition without strong justification. So, dissatisfied with the situation, the union then brought this matter to the DGIR. Considering all requirements were already fulfilled by the union, DGIR advised the company to recognize the union. Instead, the company ignored the advice from the DGIR. Then, the matter was brought forward to the Minister of Human Resource for his attention. So in 1998, the court ordered the company to accord the recognition to the trade union. The company, however, instead of complying with the order of Minister of Human Resource to accord the recognition to the union, had transferred the entire workforce to an associated company. So that action is considered as mala fide, which is bad intention. Okay, and the action has been taken towards the company to reinstate all the workers back to the company. This slide to explain about the process. So you may find this in the Department of Industrial Relations website. Prohibition to recognition. Not all members can apply for recognition. Only certain trade union members which fulfill the requirement can apply. Those unions who fail to fulfill the requirement, then the union are not eligible to claim for recognition. the requirements such as legal union, formal application, competent, and etc. Those who are in managerial capacity, executive, confidential capacity may not seek recognition for collective bargaining as restricted in the trade union membership. In regards to the issue on prohibition to recognition, the DGIR can exercise his duty and functions to validate and justify the decisions. So the DGIR can use his discretionary power as follows. First, require the trade union or the employer to provide the necessary information to resolve the dispute or to refer to the DGTU for his decisions and any questions on the competence of the trade union of employees to represent the workers concerned. Now, let us see on what problems that might occur in the recognition process. In some situations, there are the problems faced by either union or employer during the recognition process. First, the investigation by employer to check union membership. In this case, the employer might show hostility and aggression response, and the employees can also act negatively. Secondly, when two or more unions make a claim to represent workers in the workplace. Number three, employees' attitude and reactions in dealing with claim for recognition. For example, like usually done by calling and questioning employees with claim for recognition and support, but they're not encouraged. Law case, Syarikat Emerald Tas Sdn Bhd versus Menteri Buruh dan Tenaga Rakyat and another. The Non-Metallic Mineral Product Manufacturing Employees Union made a claim for recognition of the company's workers under Section 9(2) of the IRA. The company disputed the union's claim. The matter was then reported to the DGIR by the trade union. Then a membership check was conducted, and it shows that 76.8% of the workers in respect of whom recognition was sought were members of the union. So it fulfilled the requirement of the general recognition. Still, the employer refused to accord the recognition, and this matter was brought from DGTU to the Minister of the Human Resource and then to the High Court. This is another law case, which is KFC Technical Services Sdn Bhd versus Industrial Court of Malaysia and another. After a majority of employees joined the trade union, then the union decided to claim for recognition. The employer then sought an advice from the DGIR regarding on the membership issues of the union. However, without waiting for a reply and result of the investigation made by the DGIR, the employer took unilateral action, which is the decision made solely by the employer without consulting the DGIR, even the trade union, by retrenching all those employees who were members of the union, which is they have what we call the malafide in this case, only after a meeting at the Ministry of Labour and upon realization that it had contravened Section 10 of IRA, did it, I mean the employer, reinstate all the affected employees. Effects of recognition. First, enables individual members who have grievances or complaints to be represented by the union. If there is no recognition, then any grievances should be handled by employees themselves, individually or by groups. Such issues on termination without notice, delay in payment of wages, working condition, etc. Secondly, better terms and conditions on behalf of all workers in the workplace who are eligible to be members of the union can be negotiated by the union. So this can be achieved through collective bargaining, in which the final output will be the collective agreement, because it is only through collective bargaining and collective agreement the employees' welfare, socio-economic well-being represented by the union to be negotiated effectively. Thirdly, employees can be represented by the union in any trade dispute. Trade disputes such as disagreement between an employer and employees regarding the terms of employment, such as issues on termination without notice, delay in payment of wages, working condition, and etc. Fourthly, employees can take part in the union activities, including strikes and pickets. Only the employees and union who obtain or accorded with recognition can organize or take part in union activities such as strikes and picket. Fifth, employees can be protected from any exploitation or by their employers. It means that the union will represent the employees in the case of violation of rights or issues such as exploitation, discrimination, or manipulation by the employer. This slide explains on the prohibited acts or industrial action that both parties, employer and union, cannot do while the claim of recognition is still in the process or still pending for approval. It's either by the employer or higher authority like DGIR or the Ministry of Human Resource. So it can be seen from two perspectives. The first one, from the employer's perspective. So the employers cannot declare the lockout, one of the industrial actions by the employer, to the employees. The employers also cannot terminate an employee's service unless for disciplinary issue. So when it is until the claim for recognition is resolved. Second perspective, employees or the union. Employees and unions are prohibited to organize industrial actions such as strike and picket during the claim is pending. Why? Because to ensure the rights for both parties are protected and will not jeopardize anyone. This is also to ensure a harmonious relationship between both parties. Well, I think that's all for this topic. I really hope you can understand this topic. So please do your further reading from our textbook. Please find more information from the newspaper. Get more law cases for you to understand better. Wish you all the best. Bye.